We got it. All right, there we go. Okay, we are live. This is Senate Finance. 1, 2, 3, 4. Okay, we have just a quorum. Senator Rahm is occupied elsewhere. Senator McCormick, I thought, was going to be zooming in. He is homesick. Senator Bray is in the hall. I hope he will join us, but we're going to start because people have been waiting. We're going to continue our discussion about extending or doing away with the sunset on the 248A provisions or citing provisions and that possibility. So we've got Brooke Dingell. Welcome.
Thank you.
Haven't seen you in a while. Come on up.
Thank you. Brought my stopwatch to try to remind me of the time.
Don't worry about it. We are obviously not entirely functional.
Thank you very much for inviting me to testify. My name is Brooke Dingell. I'm an attorney who has practiced here in Vermont since 1994. And I've always done environmental work as well as trial work, criminal defense as well as civil litigation. I've always done at least half of my practice as environmental work. And I think the strength of my perspective is that our firm has prided itself on representing all sides of issues. So we are not a plaintiff's firm per se versus a defendant's firm, except for personal injury. But it has given me the opportunity to work with municipalities, individuals, and developers. Carl Rinker, Rinker's Communications, was my client for a long time, starting in 1996 with the Mount Irish Tower.
I was going to say, you're one of the first towers ever.
And you know, the wonderful thing about Carl Rinker was that he was born and bred for generations here in Vermont, and he understood our topography, our different communities. Obviously, he understood how we needed coverage. He started out with a two-way radio paging business, and it was Boston to Montreal. And so many of our initial towers, he was either involved in putting different apparatus on or got involved in permitting. He also helped with VTEL in terms of finding sites. So my babyhood as a lawyer was working with someone who was vastly experienced in the area of telecom. Now, of course, today we're 20 years later almost, and things are dramatically different because of cell phones. Carl showed me the first cell phone that ever existed, and the thing looked like some walkie-talkie thing from World War II. It was very large. So I've had that opportunity, and now 248A, we're here to talk about whether to reauthorize it or not. 248A came into existence during the time period that I was helping Carl site the Hardwick Tower on Richmond Hill. And it was after an investigation of where the tower should go. The town did a study themselves that they paid for. And it was to establish that their iconic Buffalo Mountain, they did not want impacted like Vermont's hilltops and ridge lines as well. And it's like their own camel's hump. It's on their seal of their for their letterheads and that kind of thing. So this was an iconic mountain that they wanted to protect, and so they identified other sites. Richmond Hill was the best one that provided the best coverage, made sure that the police could have cell phones wherever they were in the rural area. And the other thing was that women who were, or spouses that were abused, could be given a cell phone, and they would always have a way to call. It was a very important public safety aspect to it. So one of the issues that came up recently was I got contacted because there was a tower being proposed for Buffalo Mountain. And apparently there was a large outcry in the community, and I scratched my head and said, wait a minute, why is this happening? that was sacred cow, we're not going to touch that, and it was very important to the town. So I became involved, and between the community outcry and my working with Will Dodge of AT&T, who, in my opinion, is a wonderful attorney. He's very responsive to community needs, but part of the concern is, in the first instance, why was this proposed for that area? So AT&T decided to withdraw that particular application, and they have been great at working with, when I have gotten involved, my experiences, for example, in Chelsea, there's a tower proposed right in downtown. I was concerned because if it fell, it was going to fall into the cemetery. It was not, there were setbacks, the town plan provisions were not being honored. Part of that is because the PUC can override a town plan. They have a trump card. Like, you can go through the Quickie analysis and you can say there's an undue adverse impact. And yet, even given that, the PUC can say, well, we're going to override whatever those clear written community standards are. So we're going to go and give them a CPG anyway, even though under like Act 250, the same type of criteria, they would get denied. Now, we understand that this is important authority for the PUC because it gives them the ability to say, you know what, if you have a provincial attitude about something and there's a greater good for the state, then we're not going to follow what you say. We can override that town plan and do what we want. Now, in the 248A area, you give substantial deference to the towns, which is great. In the 248 energy area, they have to have an enhanced energy plan to get anything but due consideration. So you've written in a good statute because remember, 248A exists in Vermont. It's like as unusual as Act 250. In all the other states, when you want to build a tower, or most of the other states, my understanding is you go to the zoning board. Now, that's what you used to do in Vermont. That's what Carla and I did in Hardwick for Bridgman Hill. We went and got the zoning thing. It went up to the Supreme Court and down, and then we went for Act 250, and that went up to the Supreme Court up and down. And finally, you could build the tower. And Will Dodge and I worked together on the Act 250 piece of that because they came, AT&T wanted to locate on the tower that Carl was going to build. And so we worked together. They were an amicus on the case. We went up to the Supreme Court and won, which was great. Now, the problem that we have is that because you've eliminated zoning, normally if I'm an abutting neighbor or even in the immediate neighborhood, I can come and speak with the zoning board and say, I have concerns. It doesn't meet our criteria in our zoning ordinance. It violates the character of the area, whatever it might be. And they have a voice and they get to be heard. And then the decision is made. They go to a hearing and they get to speak. That's eliminated now because now you can still go to zoning and get a tower permit. You're fully welcome to at any town. I don't know what you do if they don't have zoning. I guess you just put it up and you don't need a zoning permit. If the tower is over 50 feet in height that you're proposing, then you need to go to Act 250 also. Therefore, Carl and I are in the middle of this thing in Hardwick. We've gotten the zoning permit up and down the Supreme Court. We went ahead and did it the rest under Act 250. Instead of switching over to the new fast pass 248A. 248A was put into place, I believe, because Act 250 is such a problem. That look at how long it took Carl. We were in litigation for 4 years. So 248A was, you know what, Act 250 is the problem. Everywhere else you just go and get a zoning permit. We got to stop this because we've got to get towers built. So 248A was the alternative. And it is a fast pass because most of the thousands of applications are not contested cases. Why are they not? It's impossible. I'm here to tell you it's absolutely impossible for community members, individual people, to have any say in this morass that has been created at the PUC. You think Act 250 is bad with lay boards all over the state being inconsistent with one another? This is the polar opposite. This is 3 people that never see any witness. They're given a proposal for decision by a hearing officer, some of whom are not even lawyers. In fact, the gentleman who has been here testifying for the PUC is a hearing officer, and I was making evidentiary objections recently in a hearing, and he's the one ruling on them. And I was not convinced that he understood the rules of evidence. Now, so that hearing officer is the one who has a quote hearing. There's no such thing at the PUC. It doesn't exist. And this is why. The PUC process is this incredibly shrunken timeline where the applicant, they put in their application materials and then they have to regurgitate all of their expert reports or their application materials where they make their representations. And they have to put in what's called pre-filed testimony. Question 1, what is your name? Question 2, who are you? Why do you have expertise to work here? To tell us something. Number 3, what's your opinion? Well, let me retype everything that was in their report. So this pre-filed testimony goes in. Then there's an opportunity to serve discovery if you're an interviewer. So you have to figure out how to ask discovery questions, okay, interrogatories. How do you know how to do that if you're not a lawyer? So you can ask questions if you know how. If you don't, you can, and then you get to put in your own rebuttal testimony. Okay, what do the interveners want to say? Well, they got to put it in question and answer format. They have to go out and find experts when this whole thing is all ready to go to roll at the PUC. They've been told, oh gosh, you need an aesthetics expert. Now, how do these people even know how to intervene? I defy any of you. Let's pretend that there's a tower proposed for your front yard. What would you do if you wanted to intervene and have a say on whether or not that was there, or how tall it was, or whether there was screening, or how close to your house it was, what it did to the view, what it did to your town plan? Well, in order to do that now at the PUC, even for municipalities, you have to hire a lawyer. Okay? But Annette Smith is the only person in this state. She is a treasure. If you find your way to her when you're trying to figure out, what does this all mean? How can I intervene? Do I have a say? Why can't I go to a zoning board or Act 250 and talk to them? No, Annette will acquaint people. She gives them vast amounts of information. Here is the form. Go on the website. This is the link. You got to fill out this form. You got to explain what the criteria are. You have to be able to establish you have a particularized interest that's not otherwise adequately represented, blah, 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 blah. And the bottom line is you need to go get a lawyer. So she helps them. People limp along. They try to get involved. Now, when they get involved, if they were to hire a lawyer, they would need $60,000 to $100,000. And that is a modest suggestion on my part to actually engage in this entire process and go through a contested case. That's how much money that somebody would have to pay me if I were going to charge for my time. So between Annette helping people, thank God, have some kind of opportunity for a voice. And then what happens is she runs into the roadblock of needing legal assistance. Calls me, calls Cindy Hill, maybe one other attorney, but I'm kind of it now because Cindy had other obligations and there's nobody who even can do the work. I probably spend a third of my time pro bono helping people on towers and have for the past, between energy projects and towers. I've been doing this for 3 years. I am absolutely exhausted. It is close to impossible to be able to prepare like I did for Enosburg. And this stilted process when only lawyers can engage, testimony, rebuttal, redirect, rebuttal, reply, back and forth. It's insanity. I've never seen anything like this. Now, I'm from Act 250. I'm from zoning boards. I'm from federal court on Clean Water Act violations. I'm from state court, environmental division, regular civil litigation, and I have never seen anything that could possibly obstruct or prevent individuals and municipalities from participating and having a say than what is happening at the PUC. While you've created this great statute that gives substantial deference, it is worse than an unfunded mandate. And this is why. an unfunded mandate in the education area. Well, that means you tell somebody, the school district, they gotta do something, but they don't have the money for it, and they gotta figure out how to come up with the money. Here, you're telling municipalities, yeah, you have a voice, you have substantial deference, but the problem is they don't even know what that means or how to go about it, no less have the resources for it. They're clueless. Now, we have kind of three different types of municipalities. You have big ones that have land planners that can figure all this out. And then you have the smaller towns, or even the middle-sized towns, who don't know what they're supposed to be doing with their town plan, or in the telecom area, you can have a zoning ordinance or a standalone telecom ordinance. Yeah, I'm involved over at Warren. They were about to change their zoning ordinance. And there was a land planner organization that gave them the advice and rewrote their zoning ordinance to eviscerate all of the telecom protections that they had in it that were consistent with their town plan. They took out height restrictions. They took out all the prohibited areas of hilltops and ridge lines in the Mad River Valley. I've never seen anything like it. We dug into it. We found out that this private land use consultant, these two people that are doing this work, are leaving a trail of towns behind them, eviscerating their telecom provisions because they're under the impression that, oh, that's done at the PUC now. You don't need anything. And they wouldn't look at your zoning ordinance anyway. They told that to these people. And when the town asked again, that is what we were told. So I got involved because in this particular community, I have some folks, John Egan, he's testified to you folks. He's a lawyer at Goodwin Procter in Boston. He's a partner with a global law firm. He is my primary client. I have a number of other very well-known folks who have resources who have decided this is not okay. Verizon came in with a 140-foot tower on Airport Road in Warren. Now, but for the fact that John Egan was able to buy the lease out from under Verizon because there was another company that was holding the lease option, and they had to get out of the way before Verizon came in. John was able to purchase the lease and make this go away. But since then, and that was in December, we're talking about Verizon, wouldn't engage with the town, refused to come when they were invited, canceled the meeting with the Regional Planning Commission. And it's like, the PUC is not forcing these people to do what you guys intended. That is advance notices, give them the information. Now, when Will Dodge with AT&T gives information for an advance notice, guess what he provides? He provides propagation maps. That's showing what the coverage is now and what the proposed coverage will be, so that somebody can have some idea whether or not there is a public benefit. Because the way the PUC operates, it's like, oh, cell tower, sure, de facto public benefit. And that's a huge issue because public benefit, the coverage issue as to whether or not this huge tower that you're erecting will even increase coverage, the municipalities have standing on it, but individuals do not. Yeah. Let me go, that's a problem. Because municipalities, okay, forget about Burlington and the big guys. What you have are lay boards, volunteers, if the town can even get people to be on a planning commission at all. If they do, they have people with no expertise in land use planning at all. Even if they have lawyers, that's sometimes even a worse problem because lawyers think they know what they're doing and they don't. And so in Warren, we have been dragging the horse to water and trying to explain, are you guys understanding that you know not what you do with here, what you're doing with this ordinance? You are stripping yourself of any protection or ability to tell them where to put the tower, where it's okay in your town. Okay, we don't want it in the middle of the village or next to the big brown barn that's a historic property. Okay, and we don't want it spoiling our ridge tops. So between the fact that this consultant is leaving literally a wake of towns that are now being exposed and have no law anymore to protect them. Let me just digress for 1 second. Act 250, when it came into being, and it was town plans, we're looking at criterion 10, are you in compliance? Okay, that turned a town plan, which was an aspirational planning document, into a regulatory document. It was not designed for that. It was supposed to have, we should do this and we should do that. And we might have goals that actually conflict. Okay, and what Act 250 did to the town plans, because I was asked by the Vermont League of Cities and Towns to give educational seminars to town planners to tell them, go through and search for the word should in your town plan and change it to shall. Because that was the only way in Act 250 the town plan had a voice. If it said should, they threw it out the window. So we see the same thing in a sense going on now, because this consultant group has taken shall and has turned it back to should in the town plans that they've been operating on. Now, so because nobody understands what's going on. These towns don't have the expertise themselves. All they can do is hire somebody else to do it and go, oh, that sounds good, or not. Okay, so in Warren, I think we have told them this was a problem. Last night, they voted down the new zoning ordinance because of the impact it was going to have. Now, that's all fine and good. How much money did it take us to get there? $30,000. Okay? Just to get them to understand that, because this is the other problem. They invited, after I spoke with them the first time or two, they invited someone from the Central Vermont Planning Commission, Regional Planning Commission, to come and explain. This lawyer is telling us we can look at our zoning ordinance and we should have protections in there. Tell us about 248A. And this lady, very nice lady, said 248 talks about the town plan, nothing to do with zoning. We weren't talking about 248. We didn't ask you here. I mean, that was the point. They didn't say that, but she was not even aware of 248A, where it says a town's recommendation can be based on either their zoning ordinance for telecom section or a standalone telecom provision. Even the Regional Planning Commission for Central Vermont does not know that. So Senator Cummings, I've been so busy with my practice, I have not followed the progress of this year, but I was here a couple of years ago when you guys were doing it, not this committee, but it's a House committee at the time, they were doing Act 250. And it was the big time they were trying to revamp it. And I showed up and I said, I'm here to talk to you about Act 250, but I want you to know that you're fiddling while Rome's turning. What's going on over at the PUC is far more serious and far more detrimental to the state of Vermont and individuals and municipalities who have no say in the process. At least at Act 250, it's too much involvement. It's lay boards trying to take lay testimony. It's a problem. Okay, but this is the polar opposite. This is making something so expensive or just completely ununderstandable so that people can't even know what they're supposed to be doing. Towns, not individual NIMBYs, if you want to call them. So this is what I suggest.
That was my question. How do we fix it?
And I don't know how long I've been talking right now, but
That's fine.
Okay. So what I suggest is this, and I have been in touch with my good friend Will Dodge about this, because my experience with AT&T, even though sometimes they come in at the wrong location and maybe there are good reasons for that, if Annette Smith and then typically I don't get involved because there's nobody else to call, it's very difficult to get any carrier to change their plan. Okay, but with Will, they left the center of Chelsea. Okay, with Will's involvement in AT&T, also in Hardwick, they decided not to do both.
You've heard that AT&T seems to respect local concerns.
Mendon. Now, Mendon was a situation where I charged them $5,000 and I did about $15,000 worth of work to get the tower reduced, okay, to find out what was going on, to assess the whole thing. But the reason why they were able to pull it off easily in Mendon was Terry Corsones was the head of the planning commission. Okay, they had two other lawyers, one from the DRB, one from the select board or whatever they were on. you had somebody who understood and could take my advice and do what I was telling them instead of me actually having to be there. So Will and I spoke the other day. We also talked while we were waiting, and Annette Smith came up with this idea. It is for a stakeholders meeting process this summer to sit down with the PUC and to change their process. I am talking a fundamental change to the way that they operate at the PUC. This stilted, putting everything on paper back and forth, lawyers writing every single piece of testimony is absurd. And it completely eliminates any opportunity for people to come and speak and have a voice. Fine that you require them to show what you have to show for intervention. That's fine. But you cannot leave these municipalities without the resources to engage in this process, and nobody can engage in this crazy back and forth and these compressed deadlines. Years ago, I called Will and I said, how do you, when I first got involved in this, I'm like, how do you do, pre-file testimony 1 week, then answers to discovery the next, and then the next pre-file the next week? And he said, you have to have all hands on deck. A big firm has to have all hands on deck. How can I, as one person, help these people?
I don't think so. Okay.
So I want to finish this by wrapping it up. All of this are things that my clients have asked me to say. There's way too much. I've gone on too long, I realize.
If you can leave that, we can get it put up on the website or just hand it out to the committee, whatever.
Most of these folks have posted their comments. It's John Egan from Warren. It's John Kading from Worcester. That was critical in Worcester because they had the planning commission who understood and wanted to fix this, okay? That was why Worcester worked. Now, there's Judy Wood in Granville. She makes some incredibly good recommendations and goes over this idea about how hearings, they're not even hearings. You show up and you say, yes, that's my testimony and all those pieces of paper. In Enosburg, when I tried to help them at the technical hearing to cross-examine one witness, I had to look at 6 different documents to figure out what his testimony was in order to cross-examine someone. Instead of going to a hearing, have somebody testify, take notes, and then say, let me ask you about this. What about that? And having the judges be able to answer. So look at her recommendations. They're excellent. The issue of setbacks to towers is going on in New Hampshire. There are serious health issues that arose in Pittsburgh, Massachusetts. I know those, we have to wait.
We've already been told that we can't do that, but
I know.
deal with aesthetics.
And within 200 feet of somebody's house.
If the tower goes down and it lands on the school or on any building, that is a public safety hazard.
Let me finish by reading you what HIPAA, oh gosh, I forget his last name. She's in Enosburg. She is the lady who is closest to the tower. She has a baby and like a little toddler. And she's like, I'm going to have to find another house. And there are no homes to move to in Vermont because she's not willing to live next to this tower. And she says this. It simply should not be up to citizens to educate their town select boards and planning commissions on what their role is in the PUC 248A process, like it was for me at 2 months postpartum with my second child. It simply should not be the case where even though there are hundreds of acres in alternative locations away from family residences, a landowner can pick a location on his property and move through the 248A process without so much as a site visit from the hearing officer. That's the last thing that I wanted to finish with. Is that part of what we need the PUC to do is to enforce the standards that you have required them in the statute under 248A L rules, where you require the PUC to issue rules or orders to implement the statute. That's where they need to say, you don't walk in this door until you have a complete application. And that requires all the stuff that Will's clients do, that industrial is supposed to do, and they don't. That's first of all. Secondly, besides this stilted process that needs to be revised, the rules that I'm talking about are not just giving people proper notice, but allowing them to speak, to have a voice. And municipalities must be taught what their role is if you're giving them this role. That's the unfunded mandate worst case scenario, because they don't even know what they're supposed to be doing. Thank you so much for your time. I wish that I could more easily convey this. I'm sorry I've taken up too much of your time, but this is about Vermonters and their homes and their lives, and they are not being given a chance to even speak. It's an impossible situation. Please make it for 1 year, but more importantly, require the PUC to hold a study group of stakeholders so that somebody like me or Annette Smith can come in. I can explain. Let's go like the Environmental Division. When you go on appeal from Act 250, put in your application and then have a hearing. That's what needs to happen here. Vermonters deserve it. And what you folks have tried to provide in terms of community input is not happening. So I implore you to take control over the PUC process, make it in practice the way that you intended it. Please, your constituents and all of us in Vermont are depending on this. Thank you so much.
Thank you, because this is the first real feedback we've gotten since many years ago. When we first started doing this process, the complaint we got was the PUC process was set up for a utility attorney and a utility attorney, and everybody knew the rules. And now you've got Joe Schmo, the neighbor, who doesn't know the rules and doesn't. And we thought we'd made it a little better, but apparently not better enough. And I'd like to know why the League of Cities and Towns doesn't have some instruction for towns in how you do this, or I think we'll talk to them.
If you're going to allocate money, why in the world would you give it to the industry that is going to be profiting from this and not help the towns?
Yeah.
Give the money to the towns so they can get experts.
Okay, Senator McCollum has a question. He's up there.
I'm sorry.
You're muted, Senator.
Sorry.
Bill.
Can you hear me now? Okay. Thank you for your testimony. I'm wondering if the underlying issue here is simply that the law, well, the first of that the technology is so complex and the ramifications of the technology so extensive that the law is so extensive and complex that getting a process that actually addressed all the issues you're talking about would be, then we'd be hearing from people that it's just too cumbersome and too expensive and takes too long.
I'm not sure I understand what the question is.
I don't either.
Is it in the nature of a regulatory process that deals with a complex technology with many ramifications, that the law by its nature, given what the law is about, the law has to be overly complex and too big, and that means the process becomes cumbersome by its nature?
No, I don't think so. Because first of all, the criteria were imported from Act 250. There are a few others, like the public benefit issues and that kind of thing. But, there are far more complicated issues for when I did the Williamstown Quarry for Pike Industries, my gosh, we went through 28 hearings. Each one of them was like 5 hours long. It was a very complicated we had hydrology and it was quite something.
I think that was the first time I saw you.
Oh, pregnant, out to here.
Yes, and I was in the audience, yes.
So, no, I think that what I'm talking about is the actual process of collecting and then examining evidence and determining whether or not to give a permit. In any other venue, you would show up at a hearing. They call it a hearing, but that doesn't happen at the PUC. It's lawyers writing pieces of paper back and forth, literally. That's all there is. And you go to a hearing, and if it's not contested, hearings only happen on contested cases. And so the person shows up and says, yes, that's my testimony. And then, PIPA is expected to cross-examine all of these 5 multi-page documents to try to figure out legal standards and whether or not the evidence they presented satisfies those standards. What I'm talking about is, like, you happen in real court, and the problem is nobody goes to real court anymore. Try to find a trial attorney these days, and the amount of experience that people get in court is so minimal today that it's hard to develop this expertise unless, for example, you were in the criminal arena like I was for 10 years. So what we're looking at is needing to simplify the process. Put in your application, Will. My folks will ask for intervention. We'll wait for a hearing. We get to go to the hearing. If they want our evidence ahead of time, we can put it in. And then we all sit down with the judge, or in this case, the Public Utility Commission. Let's have the real commission there, listening to the witnesses, cross-examining them, being able to assess their credibility. If this is for example, in Enosburg, we have a case that now has been recommended for a CPG by the gentleman that is reporting to you about how great everything is going. And yet he has issued a proposal to give a CPG in a case where there are no simulations, there was no site visit, there was no opportunity when the neighbors asked to fly their own balloon, they weren't allowed on the property. And then we have a proposal for decision that says give the CPG to this monopole tower that's being proposed, when in fact it's a lattice tower. Are they overwhelmed? That's the case that I tried to help out in, and it took me 8 hours to try to even know what was testified to so that I could then help at a hearing. Instead of just going to the hearing, reading the application materials, and then going and having a discussion and getting the chance to ask questions. But utility lawyers are now just writing the testimony and sending it in. That's not, and how do you do that as a person?
All right, and I think a standard work group might be a good idea because you're definitely over my pay grade. And I think all the rest of us, that this is definitely the people that are involved should be able to figure out. We tried, we obviously did not succeed.
Well,
So,
Madam Chair,
yes,
thanks. I'm sorry that my question was hard to understand earlier. Based on what the witness just said, I think maybe I can reduce it to something simpler. Is the PUC overwhelmed? You use the term overwhelmed. Are they overwhelmed, or are they doing it wrong?
I don't know. Mr. Faber may be able to speak to that, but he thinks they're doing just dandy. But when I see Ira and Enosburg, that he decided both of those cases, and neither of them was allowed a site visit. Neither of them required any propagation studies. There's no coverage studies in either of those. How are you even supposed to determine whether there's a public benefit? What, that kind of thing. So,
okay.
Just a question. You have a case in which you're dissatisfied essentially with the methodology of the result. Do you have any appeals rights or any ability to do anything other than say that there's a problem?
Well, for appeal rights, it's substantial deference. I mean, it's, I'm sorry, abuse of discretion.
Mhm.
So so you go from the PUC to the Supreme Court, and abuse of discretion is such a big, big mistake. It's next to impossible to get that reversed. However, we did in this energy, but I've been handling the Bennington cases, Apple Hill and Chelsea Solar, and those have both gone up to the Supreme Court. And we were able to get the PUC reversed on, the abuse of discretion. So we actually won in that. And by the way, 248 is the exact same horrible process that 248A is, this pre-filed testimony nonsense. It's horrible.
Okay.
And will anyone disagree with you?
I don't know, Will, do you disagree with me? gets to
Since I'm gonna be a
talk later.
witness, I'll wait to reserve my.
Okay, yeah.
It's from the town's perspective.
That we canceled the rest of the afternoon, so we're gonna be on this.
Thank you so much for listening.
Thank you.
It's so frustrating, and I can't help people. I'd say, I've been doing 2 jobs really, and it's exhausting.
Okay.
Please help us.
We need, if we're gonna set up a process to help people, we need to make sure it's helping people, so.
Senator Cummings? It might make more sense to have William Dodge go next.
Okay,
Seems like there's a bit of a back and forth that may be able to be closed.
that is up to you.
Is that-
I have Sydney Atkins next.
Yes, but I'm happy to,
Okay.
Got it.
All right, yep, let's do back to back. Your name has been taken in vain, so.
And I'll extend the same compliments to Brooke Diggleby. I have wonderful memories to this day of working on that Hardwick case with her, and she's an excellent attorney. And although, as you'll see, we don't see completely eye to eye, there's certainly a lot that we do see eye to eye on in this context. So, as I said, my name is.
I have a technical thing. Senator McCormick, do you have a question? Is your hand just still up?
Oh, I'm sorry.
Okay, I miss you occasionally, so I want to make sure that I'm not missing you again. All right.
Absolutely. Well, thank you, Senators and Madam Chair. So my name is Will Dodge. I'm the Director and the Deputy Managing Partner at Downs Rockland Martin in Burlington. And I've spent most of my legal career working in the wireless telecommunications industry. Since 2009, when Section 248A was first amended, DRM has submitted hundreds of applications to the Public Service Board and Public Utilities Commission on behalf of AT&T. The benefit of Section 248A has been a more predictable, manageable, modern, streamlined system to ensure that consumers have reliable, up-to-date wireless service in Vermont. And that includes the populated areas of Vermont, like Burlington and Chittenden County, but also gradually, not as fast as we'd like, but has gradually started to reach some of the less popular areas of the state. Simply put, it's proven to be more fair, more workable, less onerous than the alternative, which is to require virtually every telecom project, whether it's a new tower or replacing an antenna or adding a generator, to obtain both Act 250 and local zoning permits. So I'm not discounting some of what Attorney Diggleby said, but when you're facing the alternative, we think it's a better system. With respect to H70, which I know there's been some discussion about, as I testified previously to the House Committee on Energy and Environment, the proposed legislation would lead to a host of problems. Virtually every proposed section is problematic for AT&T and would frustrate Section 248A's goal of improved wireless service throughout the state. So to very briefly restate the 5 biggest concerns that we have about H70. The first is that the height limit change to 248A B2C renders putting small cells on utility poles and new rooftop installations almost impossible to permit, which is likely to lead to more macro towers and that would otherwise be necessary. I don't think that that's what anybody wants. Secondly, the idea of having private parties organizing public meetings is problematic, right? It creates a host of logistical and even jurisdictional problems that don't exist today. And frankly, we don't think it's necessary. We think there's other, what I would say about that is that during the pandemic in particular, when a lot of municipalities that we were going into who did not have very experienced planning and zoning staff We worked with them and did hearings via Zoom, municipal level without the PUC, but with the Department of Public Service involved. And honestly, it worked great. So much so that we found that it has helped make it much easier for people watching to watch from home in the first place, but also to look at our evidence, see it up on their screens, and also present their own evidence on the screens more easily than was true when we were doing a lot of the zoning hearings or the public hearings in person. The third point is the change to 248A C1 that would require AT&T to show no practicable alternative for a new tower site is vague and is contrary to federal guidance, which uses a materially inhibits standard, and it also shifts the Act 250 burdens on aesthetics entirely to the applicant. Probably the most important thing that we're worried about with H70 is that the proposed change to 248AR would extend what is now a 30-day intervention process under the PUC's procedures orders to a 60-day statutory period. If you combine that 80-day advance notice period proposed for 248AE plus 60 days, you're basically at 140 days before the PUC even starts to consider the application. The result, there's very little hope of meeting the 90, 180-day review period that's already in the statute, or complying with the federal shot clock standards in 47 CFR 1.6003. So it's destined to just slow the process down and also to spur more litigation. I don't think that's what anybody really wants. And then the last thing is in 248AS, it refers to a court remedy for municipalities to recover attorney's fees and litigation costs, but from an administrative proceeding. And that just seems to us to be misplaced, and also seems like it's just asking for more litigation rather than trying to address some of the core problems. So from our perspective, the key to successful legislation is making sure that a statute's spirit and key concepts are being implemented responsibly in the real world, not necessarily just adding more words or longer timeframes to a statute. AT&T has prided itself on trying to implement the statute in a way that is fair and transparent to those who live, work, and recreate throughout Vermont, which we understand are our current and our future customers. And also for resolving what can be particularly contentious issues with new tower sites. And just to stop there, and I don't have the exact number, I'm sure the PUC does, but I would have to guess that 90% of the 248A applications are all modifications to existing sites and that have little to no controversy whatsoever.
They
So-
have testified that there are not a lot of new towers, that most of the hearings are.
Right, and I would say that to the extent that Brooke and I have disagreements over things, most of those are likely to be in that 10% that I'm talking about that usually involves new towers or a brand new type of structure. So over the nearly 14 years that we've been using the statute, AT&T has made countless project changes based on community input and feedback. And most of that usually happens at the advanced notice stage. So that includes shifting locations, shortening towers, conserving properties, changing tower design types, altering the colors, switching the generator fuel types, and moving small cells to poles on opposite sides of the street, among many other accommodations. So just to go to the Buffalo Mountain example that Brooke gave, that was an interesting one because I was very concerned about putting a site on Buffalo Mountain when we started the project. But the town had said, well, or there had been parts of the town government who said, well, we're okay with it because we really need coverage in this area of town. And we'll even give you a license to use part of the town forest to get up to the site. But it quickly became apparent after we filed that was not a very good option. And that all the things that Brooke was saying was exactly right. That's, it's on the seal. Not that we hadn't necessarily talked about these things, but sometimes you have to do a reverse pivot even when it looks like they might be a clear.
Well, I think we did discuss in here that not all towns speak with one voice.
It's absolutely true. That's absolutely true. And nor should we expect that. But I think what we like to see out of the process is that at that advanced notice stage, we get all the voices we can, right? Pro, against, somewhere in between. And that's usually that in between is usually where we're trying to be. In other words, a way of making sure that the facility still works in a way that's reliable for our customers, but also can address some of these various concerns. So when the process is done right, it's an iterative process. It moves around as you go, but it results in better siting decisions and ultimately better service for Vermont. So we understand, especially coming after Brooke, that there have been some applicants who've been less than transparent in how they've approached the siting process, and in some cases behaved in a way that has deeply offended the host communities. AT&T does not want to see this process abused, understanding that going back to Act 250 and local like we had before, at this stage would create a host of legal and logistical problems, and in turn imperil the investments otherwise being made since 2009 in wireless expansion, broadband improvements, and public safety. So is there another way to keep the statute intact while addressing the perceived shortcomings, particularly for new tower applications? And I think the answer is yes. It is that section 248AL that's already in the statute, right? That provision authorizes the commission to issue rules or orders implementing and interpreting the section. Right now, we've had a standards and procedures order that the PUC put in place that's been essentially stagnant for 10 years, and including for the advance notice process and the submission requirements. While the commission has held dozens of workshops since just the beginning of the Scott administration for solar, energy storage, EVs, interconnection, all those things, the last time the PUC held a workshop on 248A was 2010. So that's a long time, and there's been a lot of water under the bridge since then. So given that, and considering how many times the sunset, also you all have extended the sunset and maybe extended again, the commission can and should convene a workshop with the relevant stakeholders. And I would include that not just the agencies, but also the league, as it's been mentioned, the Vermont Planners Association, to get at some of those concerns that Brooke raised of the sort of disparity in understanding, and others to develop fair and workable procedures addressing those concerns that gave rise to H7 in the first place, including, but not limited to, how to do communications and public meetings during that advance notice process. That successful workshop would in turn provide a basis for the PUC to update and upgrade its current standards and procedures order.
Okay, if either you or Brooke can submit, if you haven't already, ideas of, it sounds like this workshop might be, it is a standard form. It won't be a summer study. We'll just tell them to do what they do. Who would be important to have included, and topics that we might include in the statute to make sure that everybody gets heard and that the topics that need to be addressed get addressed. And I think, because I haven't heard on this committee yet any real enthusiasm for doing away with 248A, but we have heard some concerns and are looking for a way to make it effective. And I haven't heard any of you say we should do away with it either, just make it more effective. Okay.
I would say the only, if I can finish, Madam Chair, the one item that we would recommend that the committee members think about is a provision authorizing the PUC to review what are known as eligible facilities requests under a federal regulation, which is 47 CFR 1.6100, implementing a federal wireless deployment statute that was passed in 2012. And EFR refers to a modification at a wireless site already in existence that could include things like battery storage, resiliency measures, antenna upgrades, and compound expansions, all clearly set out in federal regulations. The statute, the federal statute, guarantees that EFRs be approved once a state siting authority determines that a particular modification qualifies, which is very similar to what already happens with the de minimis modifications.
It sounds like the de minimis.
Exactly. But the net effect of it is to encourage more changes at it, more co-locations, and more changes on existing permitted sites, rather than spurring a proliferation of new sites designed to accommodate, let's just say, one single provider. And that helps to reduce costs for everybody, for the company, but also for consumers and while creating conditions for more competition in wireless service. And it creates a strong incentive for replacing utility poles to accommodate small cells, and which can in many cases then reduce the need for new towers that, as we've said, are where most of the controversy generally lies. So the PUC has taken the position that it lacks the power to review VFRs without legislative authority. Yet there's no question that both the PUC and the department have personnel, particularly the department, have personnel experienced with wireless project types to carefully review and approve qualified EFRs. So I produced a chart. I've given the chart to the Legislative Council that shows kind of what would be not permitted as a de minimis, but would be permitted as an EFR. And what I would say is the enabling language for that could be as simple as just adding the word "and eligible facilities requests" to 248A-K, right, to the de minimis modification statute, so that EFRs are reviewed in the same manner and with the same timeframes as de minimis modifications. But other than that, we are very fine with H110 the way it is, and we really appreciate your consideration, all the work that you guys are doing.
And you have submitted this to Jill?
I have.
Good, because I'm not gonna trust my memory to remember all this.
That's okay.
Yeah.
That's okay.
We didn't get to Romanesque once.
Yes.
We get to Romanesque in economic development frequently. Senator Bray.
Good afternoon. So thanks for your testimony. Can you talk a little bit about co-location and incentives to co-locate or disincentives?
Yeah.
Sometimes I hear that it might be a carrier that will have an incentive to create their own tower because they might ultimately draw other people to that one to co-locate, and then they're getting basically rental income from leasing space in the tower. And I don't know to what degree that really is part of the business model or not. And if so, how do we avoid a proliferation of towers and push people towards co-location?
Well, so it's a great question. It's a complex, there's many facets to it, but in general, if you think about if you and I are tower developers, we go into business together and we say, okay, we've got a choice. Better yet, you and I are carriers. We just want to get better coverage through the state. Our choices are, do we need to go and build a new access road, buy the steel to put steel in the air, get all of the permits, go through multiple processes to put up that new tower, or if there's a tower already out there that will work, that our engineers tell us will work coverage-wise, what's the better economic decision? It's very clear that co-location is always the better economic decision. If there's nothing to co-locate on in a particular area, okay, let's just take the Middlebury Snow Bowl, right, where AT&T put in a tower, in part because public safety had said that Route 125, there's no coverage on it at all. So AT&T says, well, if this is going to be a costly build. We found one of the only places where we can build in the area. Let's build a tall enough tower so that others will co-locate on it. And so the effect of it is on what we call the macro sites, the tower sites. It may make something taller in order to accommodate co-location, but doing so means that there's ultimately, if it's done right, less environmental impacts by making that decision, because you're not going to have a separate access road, more clear, et cetera. Now, when it comes to utility poles, it's a little bit more complicated because utility poles can only take so much usually, unless you want to make them really tall, and then having a very tall utility pole right outside your house, it might not work. So co-location, multi-carrier co-locations work great for towers. They also work great for rooftops, right? If you've got a tall rooftop, you can put several arrays with different carriers on top of that roof. But with poles, it's not quite as simple. It doesn't mean you can't do it, but it's more difficult because of just real estate and also potential interference among the carriers.
And one of the questions, so we started with, you said, well, say you and I are developers, or let's say you and I are carriers. So
Yeah.
to what degree is the cell world served, like developers going out looking to get it? Basically, I don't know if they own the tower, lease the tower, and so their whole model is find good locations, put up a tower, get tenants, versus a carrier saying, we need coverage, we're gonna have to do this ourselves.
The truth is, it's both. Most of the, I would say, in Vermont, it's hard to give an exact percentage, but it's gotta be close to maybe 30 to 40% of the, let's say, the applications that are going to the PUC are coming from tower developers or new towers. And what they're doing is they're making a gamble of some kind, or if they're doing it right, they've already got a commitment from a carrier that says, yes, if you build it, we're going on it. And sometimes they'll have two. So I'm thinking of an example in Barrie where Verizon was making the application. AT&T was looking for a site to co-locate on it in the very same place and submitted a letter of intent to the PUC to say, if this site is approved, we will go on it. So it's a commitment. Now, where it's problematic, and Brooke and I were actually talking about this before, is what if there is no commitment? Is it okay to simply, make a case that a tower is needed here and then build it? Well, that is starting to happen with the PUC. I think it's something that, again, I would imagine of the topics that we would put in the list that you were asking for, is there a way of making that a more responsible process? Maybe something like saying, yes, you can get something permitted, but you can't necessarily build it unless there's an actual commitment from a real carrier within some time frame. Yeah, these are things that might be easier to work out at the workshop stage.
Yeah.
So there's no public good to demonstrate on a purely commercial tower that they attract tenants.
It's hard to say. Let's just take a town like, I'm not picking on Sandgate, but let's take Sandgate, because I'm pretty sure there's no service in Sandgate. You could make the argument, well, if somebody would come and build a tower there and show that it's all permitted and approved, we're much more likely to get wireless service in Sandgate than if we just kind of leave it and hope that it's eventually going to be on a carrier's budget or, that's really, because the economics, of course, for Vermont is that every time a decision is made about putting a new site for a carrier in Vermont, that decision is being made competing against putting one in Boston to deal with, orders of magnitude greater traffic or public safety issues potentially than what we have here. And yet, as we all know, everyone here wants to be able to use their phone. They really need to if they're on the road, even out in, camping, recreating, living.
Okay, any other questions?
Madam Chair,
Senator McCormick.
thanks. The previous witness led me to understand her testimony that there are citizens and communities that have legitimate issues with proposed developments and who really do not get an effectively fair hearing, that they basically get bullied, and that I don't want to put words in anyone's mouth, but I got the sense that the idea that the skids are greased, and that it's a foregone conclusion that the permit is a good thing, and that people who may or may not have legitimate reasons for arguing otherwise don't have a full good opportunity to make their case. Would you comment on that?
I will. I'll comment with a war story, which is that frankly, sometimes it really is difficult to get it right. But I'd like to think that even in communities with no experience with the 248A process, that when it's done right, by the end of it, they will not only feel good about the process, but will have walked away, if we're doing our job correctly, when we're done the advance notice process, a town select board or a town planning commission has issued a recommendation to us to give to the Public Utility Commission saying, yes, we're in favor of this process. So let me give an example of Chelsea since it was brought up. So in Chelsea, we had a heck of a time. We were trying to cover the junction of Route 110 and 117, right in the center of the village, historic Chelsea Village. And we knew that probably the best place to be was up on the hill. but we could not get an agreement with the landlord. And so we tried for another option. We found something that we thought might be okay by it's an affordable housing development up on the hill. And we got a raft of opposition right away and immediately said, this is not the right place to be. This is never going to work. Then the sheriff who we were working with, Bill Bonyak, said, well, why don't you come down and rebuild the tower in the village itself? We already have a tower there. You could simply rebuild it. We got slammed on that one too, not just by the select board of the planning commission, but also by the historic preservation commission. So we said, well, that's not good. Boy, we are running out of areas. We had a taker who had a property that was next to the cemetery. And we weren't crazy about it, but we thought possibly here it could work, or it may ultimately point to other places that will work. We went there, same thing. High school objected. Lots of people got involved, right? And next to the high school. We had kind of some mixed signals on that one, but once we actually went to the advance notice process, it's very clear not the right place to be. What that then spurred was a reconsideration of one of the owners of the properties who had existing towers to say, we're okay, we're comfortable with you coming up here and replacing one of the towers. Once we did that, the town not only had understood a lot more about the process, but was able to say, we've now seen various different options. This is by far the best option. We recommended the PUC that you go here. So I'm not sure that I totally answered your question, but what I am trying to illustrate is there is a way by which even communities that have no experience can send very clear messages to us as the applicants. And it really just becomes a question of, are we receiving those messages loud and clear? And do we want to actually get something
Yeah,
done?
and I think that's the question.
Right.
If you want to play by the rules and, you know, give the town deference, then you don't have to replay it at the PUC. But it sounds like some people don't, or at least don't initially. And then the question is, who counsels, you know, you're willing to sit down with the town and the planners, or, you know, who counsels those towns? Because
Well, I think the
Chelsea is
statute-
not
Oh, sorry, Mary.
that's small. I mean,
Right,
You lawyers.
they have lawyers.
right. And the other towns have work with planners, and those planners are usually speaking with their lawyers. I guess my sense is that I actually think that many of the approaches that we take are required by law already. Whether there's others who don't believe so, we could have arguments about that, but therein lies the point, which is at this stage, the sensible thing to do is to try to tighten up those standards and procedures.
Maybe we should change the should to shall. Do you have a question?
Madam Chair, remember when the changes were made as cell phones were becoming more popular. And the discussion over and over again was, we're not trying to evade Act 250. Act 250 is backed up. It isn't getting things done. We need to change the law to relieve the backed up applications. The standards are gonna be the same, the towns are gonna have, and citizens are gonna have the same rights. There's no intention to change anything, they're simply trying to make sure that the current backlog is resolved. And when witness here started, talked about streamlined procedures and moving things along in a streamlined fashion. The successful resolution in Chelsea was not a streamlined fashion. It was more like the way Act 250 works, which is try to work out the differences and meet community people and speak the language that community people speak. And I think most folks figured what went on in Chelsea took a long time and was contentious, and people had to work hard, and it certainly wasn't streamlined. When it comes to Act 250, when it comes to lining streams, there's not a lot of benefit when streams are lined.
Okay. But,
Can I respond very briefly?
yes,
So just to say, I definitely think Chelsea, if I didn't make that clear, what falls in that 10% of the ones that do not go streamlined. In other words, it was not part of that 90% that normally works. The other thing that I will say is the difference between handling something like Chelsea with Act 250 versus handling it in the PUC is that with Act 250, they would not have been able to consider off-site alternatives and not be factoring coverage or service improvements into the equation. The Public Utility Commission under 248A, by contrast, has that. Now, we could argue and quibble and say, well, maybe the Act 250 has that responsibility under federal law, but let's face it, the PUC, and we certainly don't always agree with them, has a better understanding of that overlay between federal, state, and ideally local than would be the case with if this were all done at Act 250.
I think, yeah, the expertise, I think, there, which is why 48A is there. Any other questions? Okay. Thank you.
Thank you very much.
Okay, I'm going to move on to Sydney Atkins. And I think this is your first time here.
It
We
is.
just ask you to introduce yourself and who you are representing.
Absolutely. So my name is Sydney Atkins, CEO of Mac Mountain. I'll give you a little bit of background on, but by need an introduction, I live up in the Killington area with my wife and my newborn. We have a 4-month-old with another one on the way, which might be a testimony of insanity, perhaps. But we have another one due in June, so we're going to be a very busy household. We also happen to own an inn and a distillery up at the base of Killington, right at the base of the resort. So I'm a Middlebury grad, so fell in love initially with Vermont. Was raised in Massachusetts, fell in love with Vermont to come up for school. Took a brief hiatus back for grad school and back in Massachusetts, and feel very lucky to be able to live, work, and play back in Vermont now. So it's a pleasure to be with you, and thank you guys for having me. So, Madam Chair and Senators, thank you for hearing about Mac Mountain. I think we've all have the places where we know our cell phone coverage is going to drop. And unfortunately, as Vermonters, and now I've come as a business person in Vermont, I've come to even understand this even better, where we have acclimated and created these adaptations where we know if we're going to go out and play in the woods, we know, okay, I need to make sure I'm safe. We ask our kids to call us when you get home to make sure you're okay. If you're going to be home for dinner, you know the spot that you're going to drop your call when you go up. And so this is not only become a public safety issue. I think as Vermonters, we've kind of just accepted that this might have to be the way things are. And I think that was really the beginning in the inception of Mac Mountain. Became rolling up our sleeves and starting to ask questions about why is this the case? Why are we accepting this as the new normal? And is there a way to think outside the box? My predecessors, Will spoke a little bit about just some of the obstacles that have come in the way of getting comprehensive cell phone coverage to our state. We've tried to come up with solutions to what we've viewed as the main impediments, right? Our topography, the reasons we all live here, that's certainly something that has drawn us here, but that's also when it comes to our view sheds, when it comes to the signals that we're projecting down into our towns, it has absolutely been an impediment to providing comprehensive service. We also had a great question on the co-location, right? If there was an economically feasible model to have delivered cell phone coverage to Vermont, we wouldn't be sitting here, right? The carriers would have figured out a way to do it. So Mac Mountain is coming to you guys to present what we think is a solution and a proposal. We hope other people will join us. I wanted to put a precursor saying, I hope other people will join us in delivering this solution. And so we're not necessarily presenting this as in a self-advocacy way. Beyond, I think that we are at a place where we can start to take action. You all have paved the way with your groundwork and your investment in power.
that you, in collaboration, with the CUDs, have made an incredible effort when it comes to fiber. We've also started to make huge strides forward when it comes to the infrastructure we needed to, mapping all of the gaps that we've had with the money that was allocated to the Vermont Drive test. And yet the conversation still seems to be reeling around, what else do we need to do to identify these spots? We're coming to you saying, I think we have a pretty good idea. Let's get started and let's try to put something, take one step forward to delivering comprehensive service. When people ask, what is the tagline of MacMountain? What's the point of MacMountain? I would really say trying to deliver cell phone service to the gaps that are otherwise uneconomical or unfeasible.
So what do you do?
It's a great question. So we are working with carriers to try to put up small cell towers or existing location antennas that can co-host signals. So carriers will be able to come and roam off of our network. So a good example is that we are doing a pilot program, and it will be 9 miles, or I should say 10 miles, stretching from Pomfret all the way down to South Woodstock. That will be 6 different locations, and it can vary. We have a location at Saskadina 6, the ski resort. We have a location on the top of a Woodstock firehouse, the roof of the Woodstock Fire Department. We've also really worked very closely with community. I mean, that's, my predecessor spoke very deeply and passionately about the importance of community. So we've worked very closely with landowners, with the emergency services to try and say, what are the right spots for this? And how do we then optimize a signal to try to put together, we consider a unit economic community. So how can we get coverage across this community where there is none? Now I'm going to briefly just share a map with you that might visualize this a little bit better.
Yeah, can you share screen?
Yeah, I'm going to share my screen and it should be able to pop up. What do we think? Oh, all right. So to just give you a quick walkthrough, this is the work that you all have done. So thank you. Each of these little hexagons is the Vermont Drive map, and the lighter the color blue, the less service. So I'm hovering over this one. You can see the pass rate here across all the 3 major carriers is 0%. Unfortunately, you'll notice the trend that there's a lot of light blue, even as we get darker. Let's pick something. I'm coming up in here. This is still only 15%, and we're still a few hues of shades of blue advanced. There are very few that are really robust at 100%. We're looking at very low levels, and certainly when you look across carriers, it's pretty small to see that there are multiple carriers providing service. So we think this is really driving the need for not only these small cells, in this small tower, but this co-location. The idea, we are asking the state of Vermont to help us take a different approach. If we own, between MacMountain, between the state of Vermont, if we are able to put up these antennas and provide this equipment, we can have these carriers come and roam, and we can provide service and start to assemble a network that can be comprehensive in the state of Vermont. Folks can be driving off on an AT&T licensed network, hop over to a CBRS network, which we can talk Citizen Broadband Radio System. We can talk about how the network is hosted. But you'll see here, there's a lot of blue here that is uncovered. I wanted to show you that the rest of this map, you'll see a bunch of these checks. So these, the red here are fatalities. The orange is an injury, and the yellow is just property damage. The public safety importance, unfortunately my colleague Rob Blish, who's going to join us, had to board a flight. So he also happens to be the chief of police in Woodstock. So I will I can by no means speak nearly as intelligently or from the experience that he has. But here we tried to overlay both the traffic data and the crash data to just start to see the importance of, if we're not able to put this, piece this together. Last week, you guys were reviewing the importance of E911 and the backup systems. When you have these massive chasms, so just to back up, the checks here are the crash types. And then if I hover over these pink bubbles, you can see this is the 4,493 people driving on that section of road. You guys are all familiar with these are the pilot sites. This is this stretch from Route 106, the 10 miles on this corridor. I'm just going to move up to Montpelier so you guys can see where we're sitting. You probably all coming in and out of here have experience with this. So you can see here, just real quick, we have 7,000 drivers a day on an average daily traffic volume.
So this is really interesting data, and I'm trying to understand the connection between this data and the bill that we're looking at in terms of.
Yeah.
48.
Yeah, so Mac Mountain obviously is trying to produce solutions, and we're trying to look and say, how can we, it's going to require a number of sites. It's going to require putting infrastructure on existing rooftops. It's going to use small cells. And we are a great example of what Will was saying, when if getting any of this through starts driving us to macro solutions, we think we have alternatives. We think there are ways in which we can avoid many of the problems that we continue to try, continue to come up against, and we haven't had success in getting cell phone service comprehensively.
Are you asking to modify the 248A process to accommodate a different sort of application, like a series of small towers, or where are we going?
With regard to 248A, I mean, we completely agree with the way things have. I think that the forum suggested is a wonderful idea. I think that I am here speaking on behalf of a massive proponent for the continuation of 248A, because I do believe there's opportunity for us to evolve the way cellular infrastructure has been implemented thus far. And I think we are in need of doing this at a greater level, not necessarily with the macro towers, and that is going to require permitting.
Have you talked to the Department of Public Service about this plan?
Yes, we have spoken with June Tierney and others extensively about just possibilities.
And I assume that our small cell inventory doesn't work for you?
Well, I think one of the major the major reasons we wanted to be able to speak with you, Clay Purvis did make a joke that he has storage units filled with equipment that unfortunately we did try to
figure out how to convert.
Yes, we tried to look at it and see if there was any feasible way to utilize what exists, and unfortunately, I don't think there is. And I understand that
We're back to the planter option.
we're back to also trying. There's scar tissue here. We've tried to do something, and it hasn't necessarily worked in the past. I think we are at an interesting point where I think technology has evolved. I think in partnership with, it would be required to, 248A and the legislature would be required to be able to move something like this forward, but.
Okay, I'm gonna go to Senator Chittenden and then.
Just maybe it picks up on where you were. You mentioned a pilot. Did you go through the 248A process with what you've done down in Woodstock? And what have you learned from that?
Yeah, thanks for the question. I think we are embarking on the 248A process. I think we have taken two things very seriously. One is the community component. So we've gone through and had these discussions with landowners, what makes a lot of sense. And the other piece, which we'll mention, is that having a carrier on board. So we are really trying to make sure that that is solidified. We don't plan on building on spec. We want to make sure that a site, this entire corridor is optimized, to provide the best community benefit. And so, we're embarking on that process in the coming weeks, and hope to have something in the ground, or on roofs in the ground, et cetera, by midsummer. That's what we're aspiring to.
Senator Gray.
So is your, I'm a little dull-minded today, I guess. Is your ask as simple as you're hoping we don't sunset 248A?
So we're hoping you don't sunset 248A, yes. We also think the legislature that you have, and the bills that you reviewed and passed in this last week with regards to public safety and the role that cell connectivity can play when it comes to being a public safety device. I wish that Rob was able to speak to it, but when you look at alternatives as secondary systems and the amount of infrastructure and capital required when we're all walking around with cell phones in our hands, and we could have folks be able to call in and, report these crashes that we're seeing. And we could be able to have dispatchers, if their radios aren't working, or if there is something that they don't want to put on a radio, have cellular connectivity. I think the community benefit will be tremendous. And I think the technology is at a place where we should consider it.
I think as we work through the dispatch discussion, we probably will.
Well, so I'm thinking, because I think I've had my own, there's scar tissue from me working in the telecom authority when we
Yep.
tried to do a corridor from Richmond to like the Jerusalem store area.
Yeah.
To Huntington, and there were proposals, there was money, there were studies, there were a lot of things. It never got built, and I think it was like 16 small units. People were calling it at that point like pizza boxes on telephone.
Yeah.
You know?
Yeah.
And I don't know if that's the same thing and or similar. And then, so there were many of them in order because the range was so short. And because it was also a valley, et cetera.
Yeah.
So I'm just trying to understand what, besides the fact that you would like to see 248A continue, wow, is there other support you're looking for that helps make this business model feasible that doesn't
Yes.
part of the current system?
We have come asking for $10 million with the real, the caveat being that we think that we can, by Vermont, by partnering with Mac Mountain or others, we hope that somebody else, if this opens up for an RFP, that other folks will join. That there will be the opportunity for Vermont to own equipment, for carriers to come and utilize and co-locate on carrier neutral equipment to be able to provide a more economically efficient model that could be comprehensive and start to fill these gaps. I don't think the gaps, to Will's point about if a carrier is making a decision about, do I put a location here or there? The census data isn't necessarily going to support doing it, in Vermont versus someplace else. So we need to change the financial model. So our hope is that by working with you all, by working with the local CVs, we can come up with a different way of doing it. So the ask has been for $10 million. That would really allow us to do 30-ish communities, very similar to the pilot one that we are doing now. So that's 10 miles of coverage.
Where is your ask?
Our ask is for $10 million.
No.
Yeah.
This
Oh,
committee
where,
has no
where?
money.
Yes, where's?
So we can't do that.
Yes.
It has to be in the budget bill, and that means it has to come
Yeah.
through
So
another bill or proposal.
absolutely. So as of right now, the gubernatorial bill has allocated $10 million. And it has become, the language of it seems to read as a placeholder to the 2021 $100 million that got reduced and redirected towards a fiber capital investment. It is right now, the language is quite open and references continued mapping, et cetera. One of our big objectives for being in front of you today is to say, I think we have sufficient mapping to get started. Senator Gray, to your point about saying that, I don't think we need to necessarily sit here and talk more about it. I think we need to get started and put something in the ground. When we say we think that $10 million can get us started, there are inevitably going to be more than 30 communities. A community could be 2 sites, it could be 10 sites to fill in a gap depending on how big the hole is. But we believe we're at a juncture where we can start with the technology exists. You all have invested in the infrastructure. The fiber's there, the power's there, the mapping's done. We think that we should actually be able to take that language and start putting that $10 million towards putting up poles rather than, or putting up, I should say, radios and a network.
And so, sorry, you may have said this and I need to hear it a second time. You have a pilot underway?
We have a pilot underway.
How many towers does that include?
So it's 9 sites, or sorry, 6 sites and 9 radios. And that will cover an over 10-mile stretch, leaving Pomfret, going down through the town of Woodstock, and all the way down through, I'll show you on this map if I just zoom, click up, all the way down through the South Woodstock Firehouse. So it's this corridor that's quite blue here, coming down here. So, and that will be, those radios are, again, they could be on top of, one's in a cupola, they're proposed to be in a cupola, one on a firehouse, one on the existing power pole. But all would be going through the 248
But
process.
it is not, you're not building a new cell tower. Being flattest.
I believe, no, nothing that Mac Mountain would do and is proposing as a solution would be over 50 feet. We think it's, the whole concept is we can use small cells and neutral carrier equipment. We think we can come up with, that's the best way from our perspective to build a network.
Okay, I'm gonna have to start calling us back
I was just gonna say,
to focus, but
I really hope you get before Christine Halquist. It seems like this is a conversation that she needs to hear and know about and how it fits into the whole broadband plans for the whole state.
Yeah, and she's been wonderfully supportive and collaborative. I think the whole point of us being here is this can't, I believe this can't happen in isolation, and or else it, again, would have happened by now. So I think we need to be doing this
we've
together.
been focusing on broadband and not on cells for the last
Yeah.
4 years, 3
Yeah,
years.
so when we went to Clay Ferguson said, what's the plan? And he said, there isn't one. Come to us with what you think. Base technology has evolved, towers have evolved, equipment's evolved, and even the carriers have evolved quite a bit. They're now coming with what they're calling bring your own coverage. Before, roaming was a different concept. Now they're coming with this bring your own coverage. So I think there is a viable opportunity to own equipment, have a more economical way of doing it, but it's going to require collaboration.
Yes, okay, thank you.
Thank you for taking the time to hear us.
All right. Have we heard from Karen? Karen is there. Yes, Karen.
Hi, thank you, Senator. Thank you for having me. I'm Karen Horn with the Vermont League of Cities and Towns. And this has been an excellent conversation all the way around. I have to say that I wouldn't really disagree with anything that Brooke Dingeldine said about the difficulty of negotiating the process from a local government point of view. We did support extending the deadline on 248A, extending the sunset, to July 1, 2026, which is another 3 years. We would certainly support convening some kind of stakeholder group to meet with all the concerned parties about how to make the Public Utility Commission process more user-friendly. It's not. It's really hard to negotiate. We've gone through it at least once in the far distant past, and it's a little bit mind-boggling. I'm not an attorney. I'm definitely not the expert that Will Dodge or Brooke are. So I would suggest, with respect to that the Public Utility Commission holding a workshop is not a particularly user-friendly process either, and that you might want to direct the Public Service Department to hold a stakeholder process and maybe include in the language who some of the parties should be in that stakeholder process, and approach it from that direction. Just to follow up on a couple of the earlier comments, the statute does say that that the Public Utility Commission needs to give substantial deference to plans and recommendations from the municipal select board or planning commission. Substantial deference is defined to mean that the plans and recommendations referenced under the subdivision 2 that talks about what they need to do with it are presumed correct, valid, and reasonable. So we're not really clear how that has played out. The Public Utility Commission could presume that your plans and recommendations are correct, valid, and reasonable, and then they could just set them aside anyway. So we've always been concerned about that language. And then just to the question that somebody asked somewhere along this afternoon about what is VLCT doing? We do have our municipal assistance attorneys who answer questions from local officials about really any issue that's related to their function as in local government. We don't go to court or a public utility commission or a district commission, natural resources board, environmental code on behalf of municipalities.
No,
We
that
leave
was
that
my
to-
question. And
Yeah,
I'm wondering,
the private-
you know, you have attorneys, but do you ever
Right.
do workshops for towns or town leadership on, we heard complaints that somebody's telling towns to change shall to should, and that does away with their deference. So, I mean, it might be helpful if there was some educational forum that was offered to towns.
Right. We do, of course, hold workshops throughout the year on, like, pick a topic for local government. And I don't believe that we've held one specific to the Public Utility Commission process or the Certificate for Public Good process in the recent.
I think that what to do if a cell tower is coming to your town might get some interest.
Yeah. Particularly if the cell tower is in fact coming to your town. And I live in one of the towns in the Mad River Valley, so we've been I've been very attentive to what's going on in Warren, which is a pretty interesting case study right now. So yeah, we have lots of concerns with the way things work right now, and we think the stakeholder process, that's a very good proposal.
Okay.
And the other, just one more thing about the changing the effective date. If you don't change the sunset, then the statute reverts to before the local boards and Act 250. The risk on the other side is there have been suggestions in the past that they make this choice on the behalf of the applicants permanent, and we don't want to do that either.
Okay. Okay. Any questions for Karen? Thank you.
Yes, sorry.
You've got one, go.
Ms. Horn, so can you comment on, so I know you're saying don't go on behalf of a town to these hearings, but in terms of what you hear from your members, how can you rate their sort of satisfaction or dissatisfaction with the process thus far?
So, of course, what happens is that when there's a proposal in a community, that's when the town asks us about the whole process and so forth. And there are fabulous advocates out there, Brooke and Annette Smith, who work on these issues, and a number of town attorneys. But when they ask, we will talk to them about the process that's on the books, right? So we don't get into, I think I'm accurate in saying that we wouldn't get into the details of how the town would need to pursue its particular interest in the Public Utility Commission, which is sort of the advice that your town attorney would be giving you. So there's kind of a divide there. Like, we're not going to do something that's in the nature of taking the case for you. We are going to give you general information about how to approach the project and what the statute says you're able to do. You have authority to do.
So in the case of Warren, for instance, I'm just trying to figure out how it is that they seem to, at least for a period of time, got caught unawares until people threw in resources to educate themselves, basically lawyer up to solve the problem.
Right. I don't know offhand. If Warren contacted our municipal assistance center, I imagine they did, but I think I can try to find out for you. Sometimes they quote confidentiality at me, but I think I can find out for you.
Okay. Anything else you want us to hear, Karen?
No, thank you. Thank you.
Okay. And committee, any further questions? Okay, we are going to go on to Stephen Whitaker.
So. Last but not least.
Yeah, but you were here yesterday, just.
I'm not allowed to talk about this,
No.
or last week, when you had this bill before you. I'll start with start and end with the recommendation that you extend 248A for 1 year right now, and I'll lay out the reasons, and no more, and I'll lay out the reasons. The PUC workshop might the language directing the PUC or the PSB to hold a workshop should also include recommendations for any changes to legislation to effectuate that and to require to give binding effect to the recommendations that come out of those workshops. And you'll need to implement those next year. And you will be precluded from doing that if you've already extended this sunset for 3 years. So I want to point to a couple of things. We have in statute now a 10 VSA 6030 requires that the Natural Resources Board shall maintain a map that shows the location of all wireless telecommunications facilities in the state. That was effected into law in April of 1998. That provision was to address the concerns that you've heard from numerous parties that we don't know where the towers are, where the co-location opportunities are, where the dead zones are. And the Natural Resources Board was left out of the 248A process. There's no mechanism whereby the PUC notifies the Natural Resources Board that they've issued a permit to put a tower there. So the Natural Resources Board does not maintain a map, nor they claim can they. Technically, they probably could, but it's a lot of work to do it that way. The 202E of 30 VSA, sub E, requires that they work to achieve near universal statewide mobile wireless coverage. And MAP wireless service along 202C is to assure shall work to create support wireless service along all travel corridors and in community centers. So we've got a lot of the piece parts, and the failed planning and the failed oversight has resulted in this mess where we're allowing or even promoting the speculative interests of, mercenary tower builders without even any carriers lined up to be roaming Vermont looking for sites to put towers. Meanwhile, this is disconnected from what you've been studying, the public safety imperative. So we're about to start inventorying all of our public safety radio infrastructure, and including both LMR and LTE, in order to create a statewide canopy of service to support
first responders and the public's ability to call for help. And that's gonna necessitate some towers. And the question becomes, if we're gonna invest public money in towers, which has been proposed 10 million by the governor, shouldn't those towers potentially be owned by public entities like public safety authorities? Let them accrue some of the benefit of rent from a cell carrier. But at least they have a say in where these towers go that maintain coverage along the highways and that allow locating public safety antennas for the LMR two-way radio. So I'm advocating for an integrated approach here, and therefore tower siting, tower ownership, shared infrastructure. Shared infrastructure is currently in the requirements of the 10-year telecom plan, as is neutral host, analysis of neutral host that the prior Miss
Cindy Atkins.
Miss Cindy referred to. Neutral host infrastructure is there because Senator Brock was prescient enough to take that piece out of Senator White's bill that I helped draft and get it inserted in the broadband bill. The problem is they were allowed to get away with writing and adopting a plan that ignored it. And no one, even in the joint meeting of the two committees, challenged them on adopting that plan, missing that key piece. I'm glad to hear the quote that, "Where's the plan?" And Clay saying, "There isn't one." That's pretty revealing. There's a couple of more statutory sites I could point you to, but I think I've already made the point that we've got numerous statutes spread across several sections and even several titles that require inventory of mapping of wireless infrastructure, that require completion of a wireless canopy, and we're still not doing it. And my point is that the private investment speculative carriers can't make a profit in the rural areas of Vermont. And I'm going to jump back to or repeat a prior case study I mentioned. Mutual aid response. Public safety in Vermont is mostly volunteers, thousands of them. And incidents like the fire in Barrie, fires, they draw first responders from various communities. Those communities those firemen, fire persons have the cell phones that work in their communities with their family plans. Those are on different carriers. So if we want to use public safety cellular service to make sure we can find and drag the downed fireman out of a building, we need the neutral host model that allows all eligible first responders to have priority and preemption and to work, have their care, even if they came from an area like Northfield, where maybe only T-Mobile is there, or from Marshfield that only had Verizon, or from Moortown that might have had AT&T. All of those phones need to work at the sites of a mutual aid response. You understand what I'm saying? This is why neutral host shared infrastructure model is good economically. It's good for the carriers. They're not investing in 3 separate sets of radios. They're not hopscotching. Here's an AT&T zone. Here's a Verizon zone. We got dead zones between here and Danville that Jay drives every day. It's
over here in Northfield.
It's dangerous, and you shouldn't have to have 3 different phones to be able to be safe on the highway. So my point is that we should implement an integrated plan based on the current dead zones, and we should, I need to comment on the maps you saw. The maps that the Public Service Department did, those were driven by VTrans. It was my conversation with Joe Flynn at Capitol Grounds that he said, yeah, I'm willing to do that. And it got done, but it's only on the state highways. We still don't have the town roads and the hilltops mapped for dead zones. And that needs to happen in order for us to complete a cell cover canopy. So what I'm asking you is to, and I will be proposing language, to integrate this planning for cell coverage, linking it. Hopefully the Senate Approach Committee will restore some of the 10 million that the House took out but link it integrally to the public safety inventory and planning that's going on. As well as the 400,000 that's being asked for the 10-year telecom plan. We cannot afford to squander another 400,000 on another incomplete plan. So I could go on, but it's late and you've heard plenty today. I ask you to only renew 248A, extend the sunset for 1 year, and help craft this language to get into the budget, because I'm not sure that the
This
dispatch.
isn't going in the budget. This is a separate bill.
Well, I'm talking about language for linking the telecommunications, the language that might supplant S-139.
No one's told us there's money being requested in the budget for telecommunications plan. We might want to learn about that.
Well, it was mentioned in the governor's address, and the House passed 10 million. No, the House stripped out the 10 million, and the business community sent a letter to Senator Kitchell with a long list of signers on, asking for some of it to be restored. I only support restoring that or some portion thereof if it's integrated in this manner.
Okay,
Thank you.
thank you. Thank you, everyone. I think that's what we're gonna do on 248 today. We have moved the transportation fee discussion. I've canceled Sean Naylor, and I will tell you about that. We have Ellen coming in tomorrow, so we'll need to talk to her about language on this bill. I don't think we'll do, so we'll probably put Chris Roop in the transportation fees and the fee, the mileage fee on electric vehicles. Over tomorrow, Maria, well, I'll tell you, yesterday, after we adjourned, I met with the pro tem, Senator Kitchell, Senator Hardy, and told them that we were starting to feel like we were moving into GovOps on this dispatch and wanted to see what we could work out. We didn't really work out. What I found out is that they have been working on an amendment that would put the funding and the requirement for all the data gathering, that whole phase 1 is going in the budget. And they would like us to just strike out the formula and any funding and then recommit the bill to GovOps so that next year they will have that to work on. I was very clear on more than one occasion that this committee had some concerns about the guardrails, whatever you want to call them, we put around that money, about who got it, who supervised it, who did it. And so I've told Jay that I, with your permission, would like, well, I told them I can say yes, I don't know, but I cannot speak for my committee. So you can all say, forget it. We're going to keep working on it. Or we can hold on to the bill until we see the wording that's going into the budget to make sure that it meets our concerns. And I talked to Maria, who said she could come in tomorrow, but she has cracked a rib. So she might be remote, but she did not have the amendment for the budget crafted yet. So we might put that off till last week, but that.
I wouldn't like to see the money go over without understanding where it's gonna go and how it's going to be protected.
Yeah.
Right, so I would say that we should defer until we see that.
Okay.
Same here. I don't know what, we're being asked to exercise fiduciary responsibility. I don't yet know what we're on.
I'm getting to be a little concerned. This morning, we went through the workforce development bill, and it is all in the House budget.
Talk about an absence of guardrails.
Yeah,
That's another subject.
yeah. And we're getting like 10 minutes a thing to go through it. It's really, it's a huge bill. It makes this one look minuscule. So yeah, I've never seen us have this kind of a contracted post crossover time. It's usually equal, and I don't know what set it off, if it's the moves and when town meeting fell late, because it's the first Tuesday, and so, but it's getting to be very rushed, and I would like for us to see and to have some input into the into the wording that goes into the budget. I think I wasn't the only one that was surprised that we were doing PCB testing in schools, because that went into the budget at the request of education in the last minute, and the next, none of us knew that it had gone in, but it's in the school budget.
There's some controversy as to whether or not that's really necessary to do at this point.
That
There are
is,
big mixed
yes.
answers on that question.
And so we'll be doing the yield bill. They still have that. I was told today by staff that they were told yesterday, and we're trying to get Stephanie Barrett in here, that we need to put $1 million in to go to the tax department for their IT expenses. We learned this, and the chair of Ways and Means happened to be sitting with me when I heard this. And we both said, we've never done this. It was explained to me, and Stephanie will explain, that we've always paid for it. The tax department just took it off the top of the income before they reported the income to us. This is supposed to make it transparent so that we are actively allocating it. And so that's where, but we will be getting a request to take $1 million out along with the 9.1. Fortunately, the other body left us 22 million to kind of even out next year. Seeing what happens to waiting and what happens to the economy. So we will see.
So, we've talked about it different times, of the sessions, and just echoing the same thing, and it's like, I've noticed, it used to be that the budget would be a place towards the end of the session where certain things that got resolved would be inserted in order to get them on the bus that traveled for sure. And now it's starting to feel like people are piling things on the bus that includes policy from the middle of session on, which then messes up the whole committee system.
It's very hard to have a hearing when you know that the budget's gotta go Friday. And so by next Friday, we've gotta do all our due diligence on how many?
And I'm thinking of something we've
sections.
never seen before, much less discussed to take the testimony of. What we have in the economic development.
And then we had a fire. So, yeah, it's just differences. So that's where we are, unless you tell me otherwise, that's the direction I'm heading in. And now that you walk in my back, I'll go tell the pro tem's office. That's what we're gonna do. That's right. I didn't do so well yesterday, but apparently this was in the works, and I just wasn't in the works. We'll find out where it goes. Okay, thank you. Try and get you out tomorrow while the weather's nice.
I see.